So this next question asks about what are the common reasons to end up with patent litigation, and what are some strategies for resolving disputes if they arise. So I'll have clients that commonly get in this situation. They'll get a letter, maybe someone will file a lawsuit, maybe someone will approach them at a trade show talking about their patents and that sort of thing. And often, of course, they're absolutely demoralized and crushed because patent litigation can very quickly put any company out of business just with the weight of the legal fees involved. It's not uncommon to spend $3 to $5 million litigating a single patent. Now, most settle, but very quickly you're going to be spending tens to hundreds of thousands of dollars depending on how things unfurl. Now, they often don't start off with litigation. They start off with letters going back and forth. And to cheer up my clients in somewhat of a backhanded way, I'll say, congratulations. If somebody cares enough about you, you are successful enough to draw a patent litigation. They don't sue just anybody. They only sue successful people, as it turns out. So that's not much comfort for their situation, but it can bring some levity to it, in that it is a milestone that somebody cares enough, because on their end, to pursue this, they will also be spending tens to hundreds of thousands of dollars, and you just wouldn't do that for any old company out there. Is typically you have a very successful company, or maybe a fierce competitor in a space. The situation I dealt with most recently was my client had won a contract, and the company that was displaced from the contract had gone back and said, hey, we've got all these patents. It was kind of a sour grapes sort of situation. So congratulations, you won the contract, but maybe you end up in a patent litigation. So when you get that letter, don't panic. Rarely do these things end up in litigation. Often, like 19 times out of 20, they settle. And I would say in about a third or a half of the cases, they settle very easily, because there really isn't a good infringement claim, or there's some sort of defect with what they're pursuing you on, or often it'll be a licensing company that is maybe sending this letter out to many, many people, right? And in some cases, I'll counsel my client not even to respond, especially where it's not very close to anything that they do. So there is a kind of a dance that happens with these letters, is they're trying to put you on notice about a patent without ripening the disputes so that the receiver of the letter can go and take it to court to get what they call a declaratory judgment. So the other besides sending the letter may just want a licensing check. Well, any threat is a cloud over the company that receives it, and they have within their rights the ability to get out from underneath that cloud, so they can go to court and have it adjudicated. They can also set it in for administrative challenge. There are ways to kind of send it back to the patent office for far less than a litigation, and have people look at the patents at the patent office and reconsider them with a fine-tooth comb, with arguments that you put together, saying why it's not a valid patent. So there's a whole litany of things to do when you get that letter. And once you're done panicking, get to work and figuring out what you're going to do next. I would say meet with your most trusted lawyer in this space. That might be the person working on your patent portfolio, or it might be a patent litigator, but know that there's kind of a moral hazard. If you talk to a patent litigator, that's what they do. They do patent litigation. And most of the time, you don't want it to be a litigation, right? The only clear winners when you have a litigation is the lawyers that have been engaged in the process. because they're going to get paid regardless of if anybody wins or loses in most cases. So be very cautious. Go to somebody you trust in this area. Your patent counsel may not have a vested interest if they're just getting you patents. They may not also do the litigation. Sometimes their firm will also do the litigation, and they'll bring in somebody. And if it is already a litigation, you might want to talk to several firms, and they'll all give you kind of an idea of how they might approach the situation. But you can get a pretty good perspective by talking to several people in that way. And then ultimately, if it's a litigation, you're going to have to very quickly pick counsel. But at least you'll have the wisdom of having different perspectives from different people pitching you. And these litigations are so lucrative to firms that they'll put together quite a bit of preparatory information, talking about maybe the facts of the case and the people involved, the judges that have been assigned, and that sort of thing. And you can get some really good information from a lot of people pretty easily. So what happens is I'm talking from the perspective of receiving the letter. But you may be on the other side. You may be the person sending the letter. And why people send the letter or why they litigate is they want to get maybe a license, if it's a competitor, or there's certain other exceptions, but certainly when it's a competitor, maybe they want to shut you down, right? So they can be bet the company type of litigations. If they just want to get an injunction to stop what you're doing, well, that may put your business underwater by doing that. So they can be very, very high stakes situations. So you have to assess whether it's a competitor that wants to perhaps get an injunction to put you out of business, whether on the other end of the spectrum it's just a licensing company that's sending this letter out to a lot of people and they're just trying to get some revenue. For them, it's pretty unemotional, whereas a direct competitor, it's very emotional, which brings in all kinds of weird dynamics, right? When you're in an emotional situation like that, where fierce competitors are battling with each other and maybe there's some bad blood between them. So you want to size all of that up and get an idea of what the strategy on the other side is, right? But pretty quickly, once you've sized things up, and you determine that it's close enough that you want to do something about it, sometimes you just ignore them, right? You figure that they've sent this letter to 100 companies, not close to you. Take your chances. Maybe you'll get another letter. Maybe they'll file in court. But for whatever reason, you're not particularly worried about the particular patent. So you really have to do your diligence in seeing if there's a way to sniggle out of the situation while still getting what you want, right? So if you want to get an expensive license, you might see who the other licensees are. And, often there'll be a confidentiality clause, but you might have a lawyer that you know. And although they will be bound by that confidentiality often on what the terms were, there might be certain information you can glean from the situation, right? Like if it's a public company and it was a large amount, it's probably going to be in your SEC filings. So there are ways to kind of size up the problem, right? And, there's also opportunities, right? That might be an opportunity to, maybe you're the person sending the letter, maybe it's a prelude to being acquired, right? As you talk to them about these patents that they might be infringing. And, oh, by the way, we're trying to sell off this business, right? So patent litigation, I'm procuring patents for people. I generally try, and my strategies are all to avoid patent litigation because it's just too uncertain that you can just file a patent lawsuit and get money out the other end. And it's very costly to do. About half the time when somebody files a patent lawsuit do they win, and half the time they lose. So that's not, that's coin toss kind of odds, which is kind of difficult to build a business around. But if you have a less ambitious objective, right, maybe the damages are millions and you just want $100,000 because you're trying to get that maybe the licensing revenue from a lot of people. You can have strategies toward getting to settlement or some other outcome that does not require a win in court, because the win in court is the unpredictable thing. So before you get out that gun and start shooting, right, because you've got a patent and your lawyer is saying, well, by golly, patents are for enforcement, you should think through the issues. Because very quickly, when you pull out that gun, if you point it at somebody who also has patents that you might infringe, you can expect them to threaten a countersuit. Or you could end up in a situation, I've seen this before, where somebody approaches you with several patents and, a competitor, and you find out that they're infringing a bunch of your patents. And I've seen it where the person that pulled out their gun first is the person that ends up getting shot, because the person you have approached has a big patent portfolio and you are infringing it, and people will get to the bottom of it. So maybe that shouldn't be the first person that you would approach. Maybe you approach somebody after doing research that has no patents in their portfolio, or maybe they're not a direct competitor and they really don't care about this space. Might be a prelude to a business deal. It's like, look, you guys are selling into the space. We got a bunch of patents here. Can we produce it for you? Maybe you can white label or OEM what we're doing. Because I always try and get my client thinking about a business solution that they would like and how they might use the license rubric to encourage that business thing that they want. They want to get these people to resell their product. They want to get these people to buy their company. You really want to have a business objective in mind, because the pure legal objective, although many people pursue that, is a risky proposition when the odds are 50-50, right? And sometimes you can get better odds by having several successes in court, or people have challenged your patents and been unsuccessful, so it looks to be better odds. But the other side is always doing this, if they're unemotional about it, is doing this kind of business calculation. If you want millions from them, well, they'll spend hundreds of thousands of dollars challenging them at the patent office. Why wouldn't you, right? You're at least stretching out the time by which you have to pay. So kind of know what you're going into, really size up the situation. There are some organizations that will buy up patents from people. That's less risky. There's no countersuit risk. But then there's problems there too. They're buying them to go and assert them against people. So you may end up patting yourself on the back because you just sold a bunch of patents. And then you find out next year that all of your key inventors are stuck in depositions as they go to assert the patents. So there's lots of moving parts. And what may seem like a great idea initially may indeed be less than that as you go through the math. So anyway, I hope that helps. Not sure I exactly answered your question, but that was my attempt at it. Be careful. Be careful. So at any rate, if you have any additional questions, leave them in the comments there, and don't forget to like and subscribe.